Have you ever considered what things cannot be protected by U.S. copyrights? Hello and welcome. This is private U.S. copyright lawyer Eric Kelly, and in this video, I'll be addressing stuff that cannot be protected by U.S. copyrights. I'll go over a variety of different things that in general cannot be protected by U.S. copyrights. And later in this video, I'll also note some source material where you can research for yourself about subject matter that is generally not protected by U.S. copyrights. Okay, let's get into this video. I'm going to go through a list of 9 different categories of things that generally cannot be protected by a U.S. copyright. The very first category is for too short literary works. That is a literary work, a written work of too few words. So this category includes things like names, titles, slogans, mottos, short phrases, or the like. So again, names, titles, slogans, mottos, short phrases, or anything basically that has too few words. If you only have a few words or less, then there likely is not enough written content there to be creative enough to support U.S. copyright protection of that particular literary work. However, something that does have, just a few words, again, such as a name or title or slogan, short phrase, motto, or the like, something with just a few words can sometimes instead be protected in a different way under U.S. trademark law if those words are operating as a trademark. However, and in contrast, if you have a whole bunch of words generally, like if you have a short story, a novel, script, screenplay, lyrics to a song, poems, blogs, things of that nature, things that are substantial with respect to having a lot of words, those generally can be protected by U.S. copyright. And in this context here, names, that could be a name of a person, it could be the name of a company, it could be the name of a product, the name of a character, the name of a music band, the name of an artist or a performing group. So names basically refers to all those different types of names. And again, names in general are not eligible for U.S. copyright protection. And with respect to titles, what we mean by titles, as some examples, the title could be the title of a book, the title of a movie, the title of a video, the title of a song, the title of an album, the title of a poem, the title of an article, title of a blog, etc. So again, in general, just like names, titles in general are not eligible for U.S. copyright protection. And with respect to short phrases, mottos, and slogans, those are all a little bit more self-explanatory, and they basically all share the problem of having just too few words to be considered creative enough to support U.S. copyright protection. And just as another example that kind of falls into this first category would be domain names or URLs. So basically, again, because a domain name or URL is generally too short to have sufficient creativity to warrant U.S. copyright protection, domain names and URLs are not going to be something that you can protect with a U.S. copyright. Okay, moving on to the second category of things which cannot be protected by U.S. copyrights. And this second category is of what we call merely familiar, common, and or old symbols or designs. So examples in this second category include letters, numbers, punctuation, and or the symbols that would generally appear on a keyboard. But keep in mind, in contrast, if those letters, numbers, punctuation, and or symbols that generally appear on a keyboard were arranged in such a way to basically to create like a novel or a short story, then that would rise to the level of a creative work that could be protected by U.S. copyright. But basically just letters, numbers, punctuation, and or symbols that would generally appear on a keyboard by themselves or kind of arranged in some random manner, that's generally not going to be eligible for protection under a U.S. copyright. Another category in this another example in this second category includes abbreviations. Another example includes musical notations and or the notes by themselves where the notes are not arranged into a particular musical composition. So again, if you have musical notes that are arranged to create like a song, musical composition, that's different. That can and does often rise to the level of a creative work that can be protected by U.S. copyright. But just musical notes by themselves or that are in kind of some random order, again, that's just going to be considered a common symbol that's not eligible for U.S. copyright protection. Another example in this second category includes currency symbols. Again, that's just a common symbol, like the dollar symbol, the euro symbol, the British pound symbol, the yuan symbol, etc. Another example in the second category includes arrows, directions, and or like navigational symbols that are commonly used. Another example of common symbols and or shapes could be things like a spade, club, a heart, a diamond, a star, the yin-yang symbol, a peace symbol, the peace symbol, that's a common symbol. Gender symbols are another common symbol that can't be protected on their own by a U.S. copyright. And another example in this particular second category would be simple emoticons. Other examples included in this second category include common patterns, such as but not limited to like chevrons or polka dots, checkerboards, basically any kind of common pattern. Additionally, another example in this second category would be common industry designs, again, such as but not limited to like a barber's pole, food labeling symbols, hazard or warning symbols. A further example in the second category would be common religious symbols. And then the last example that's usually given for the second category would it be what we call common architectural moldings. So like a common crown molding, shape, or profile. Again, those are all going to be common shapes and or symbols that because they're so common, they're basically already in the public domain, and so they're not eligible for U.S. copyright protection. Okay, moving on to the third category of things that are generally not protected by U.S. copyrights. And this third category is basically mere variations of typographic ornamentation, such as lettering or coloring to lettering, and or typeface as a typeface. Basically, again, typeface is generally not something that can be protected by a U.S. copyright. And this should be kind of intuitive since we've already discussed in the second category that lettering, numbers, and symbols that generally appear on a keyboard, for example, or that can be accessed from a keyboard are not going to be eligible for U.S. copyright protection. Similarly, the typeface and or the ornamentation to, letters, the coloring, and things of that nature are not going to be eligible for U.S. copyright protection. Next up is the fourth category, which are mere listings of ingredients or contents, such as in a recipe. Basically, a list of ingredients and or the basic instructions for combining that list of ingredients are generally not something that can generally be protected by a U.S. copyright. So again, in general, recipes and ingredients, the list of ingredients are generally not things that can be protected by a U.S. copyright. However, and this is kind of an important distinction, a recipe book or a cookbook, including its photos, if any, and some of its writings may be protected by a U.S. copyright. It's just that the actual list of ingredients for any one of those particular recipes or any of those recipes in general, those things by themselves are not protected. That is, the overall cookbook and including its photos and some of its writings can be protected by U.S. copyright such that somebody is not free to copy that cookbook. However, somebody would be free to use the recipes within the cookbook without infringing the copyright in the cookbook. So that distinction is kind of subtle. It's easy to get confused on that distinction. Next up is the fifth category of things that are generally not protected by U.S. copyrights, and this fifth category is often one that confuses people that are new to U.S. copyright. And this can also include attorneys that don't usually practice copyright law and even judges that don't usually see copyright matters. So here's the gist of the fifth category. Ideas, plans, methods, and or systems, any one of those or all of them, are generally not something that can be protected by a U.S. copyright. And note in this particular context, when we're talking about plans, we're not talking about drawings like architectural drawings or blueprints. Architectural drawings or blueprints, so in that sense, plans of that nature, those are things that generally can be protected by copyright, by U.S. copyright. Rather, in this context of subject matter that cannot be protected by U.S. copyright, think of plans as like you have plans to go on a trip, plans to hang out with friends. So using the word plans kind of in that meaning rather than in the drawing sense of the word. Now, this fifth category often confuses people because of this distinction here. And this distinction is this. The creative expression, so again, the creative expression of one's ideas, plans, methods, and or systems can be protected by U.S. copyright, whereas the ideas, plans, methods, and or systems by themselves cannot be protected by U.S. copyright. So an example here should help clarify that subtle distinction. If someone writes a book or makes a video on their idea, plans, method, or system for training a dog, that book or that video in this example would be the type of creative expression. And it's that expression that often can be protected by U.S. copyright. That is, the book or the video cannot be copied or used without the copyright owner's permission. However, and here's the distinction, anyone would be free to use the idea, plan, system, method for training the dog that was disclosed in the book or disclosed in the video without infringing the copyright in the book or the copyright in the video. Again, because the ideas, plans, methods, and or systems by themselves cannot be protected by U.S. copyright. Rather, it's only the expression, the creative expression of those ideas, plans, methods, or systems that can be protected by U.S. copyright. So that distinction is very important, but it's also very subtle, and it's easy to get confused on that distinction and the subtlety there. Okay, the next category is the sixth category, which is for useful articles, devices, machines, apparatus, tools, and or the like, which generally cannot be protected by U.S. copyrights. For example, the hammer and or the nails shown here are both useful articles and as such cannot be protected by U.S. copyright law. This restriction has developed largely from court cases and is sometimes known as the useful article doctrine. However, sometimes useful articles, devices, machines, apparatus, and or tools can have both a functional aspect, a utilitarian functional aspect, and an ornamental or aesthetic aspect. And if those two different aspects can be separated from each other, then the separable ornamental or aesthetic aspect might be protected by U.S. copyright. For example, if the hammer shown had included some kind of picture or artwork engraved into it somewhere, then that picture or artwork might be protected by U.S. copyright. But the utilitarian functional aspects of the hammer cannot be protected by U.S. copyright. Also note that when ideas, plans, methods, systems, and or functional devices, machines, tools, apparatus, things of that nature, pertain to a novel, basically a new and non-obvious invention, then that invention might be capable of being protected by a U.S. patent, not U.S. copyright. So while U.S. copyright protection might not be available, and generally is not available for ideas, plans, methods, systems, and or functional devices, U.S. patent protection might be a viable option instead. Okay, moving on to the seventh category of things which cannot be protected by U.S. copyrights, which are blank forms. So blank forms of all different kinds or types, whether they are in paper, digital, displayable, whatever. This seventh category is often known legally as the blank forms doctrine. And of course, as you might imagine, there's tons of examples of blank forms that would not be eligible for U.S. copyright protection. So some examples, I'll give a bunch of examples here. The first one would be blank time cards. And the next example isn't technically a form, but it's often included in this seventh category of blank forms. And that would be blank graph paper. Additionally, you could have a blank account book, so blank accounting books. Another example would be blank diaries. Another example would be blank bank checks. Another example, blank scorecards. Another example would be blank address books. Another example would be blank report forms. Again, you could have blank order forms. Also, labels that are blank would also fall into this category. So anytime when the form or the label or the graph paper hasn't had information already put onto it, whether that be in writing by handwriting or via, a printer or whatever, if it's blank in that sense, it's generally not going to be eligible for protection by U.S. copyright law. So again, any of these examples of blank forms or the like things in general cannot be protected by U.S. copyrights. And here's another distinction. However, if the given blank form is novel and non-obvious, then such a blank form might be protected by a U.S. design patent. So while U.S. copyright law is not applicable to blank forms, U.S. design patent protection can be a tool used to protect blank forms, as long as the given blank form was novel and non-obvious when that given U.S. design patent application was prepared and filed. Next up is the eighth category, which are works consisting entirely of information that is common or that is already in the public domain, that is already public property. Basically, this is information that contains no original authorship, which is another way of saying this is information that contains no to little creativity. So common examples in this eighth category include calendars. So your basic standard calendar is going to be an example of a work consisting entirely of information that is common or that's in the public domain and that basically has little to no creativity. Another example in this eighth category are height and or weight charts. Another example would be rulers and or tape measures, things of that nature. Again, because they consist of information that's common or that's already in the public domain and that have no to little creativity about them. Another example in this category, in this 8th category, include schedules of sporting events. Another kind of catch-all category or example in this 8th category would be lists and or tables taken from public documents or other common sources. So in general, works consisting entirely of information that is common and or that already exists in kind of the public domain cannot be protected by U.S. copyright in general because such thing is either already in the public domain and or because that content has little to no creativity. And here is the 9th and final category of things that cannot be protected by U.S. copyrights. This 9th category basically states that a template for a particular layout or a template for a particular design or a template for a particular format, such as a template of a layout as applied to like a book or a page or a book cover or a slide presentation or a video, a web page, a poster, a form such as in a blank form. A template for a layout as applied to any of those things cannot be protected by U.S. copyright. However, and here's another subtle distinction, kind of similar to some of the others we've seen, the selection, the coordination, and or the arrangement of specific content, but just not any content, can often be protected by U.S. copyright. In such scenarios, the copyright claim generally needs to be limited to the selection, coordination, or the arrangement of that disclosed specific content, but just not to any content. So you can protect the arrangement of specific content, but you cannot protect the template of an arrangement that could be applied to any content. So there's a subtle distinction there. Okay. So again, to restate this 9th category, which basically states a template for a particular layout, design, or format cannot be protected by U.S. copyright. Okay. So the template cannot be protected. However, a specific selection, coordination, or arrangement of specific content, that often can be protected by U.S. copyright. All right, I've run through a list of 9 different categories of things that generally cannot be protected by U.S. copyrights. And you might have noticed some common themes that exist for at least some of these 9 categories of things that generally cannot be protected by U.S. copyright. So as some examples, I'll give you 3 different common themes that we saw for a lot of these. The first one being unoriginal things or things that lack originality are not going to be things that you can protect by U.S. copyright. And from a legal wording or phrasing perspective with respect to U.S. copyright law, this is often stated as the given work lacks authorship. If you ever see that kind of language, it basically means that the given work lacks sufficient originality to rise to the level of being a creative work that could be or would be protected by U.S. copyright law. A second example of a common theme we've seen here is that things that already exist in the public domain. Okay, so number 2 example of a common theme is things that already exist in the public domain are not going to be eligible for U.S. copyright protection. And then a third example of a common theme we saw here with some of these 9 categories is that things with a utilitarian or functional purpose, those as well cannot be protected by U.S. copyright law. Next, I'm bringing up yet another subtle but important distinction to be aware of. Each of the videos and photos I've shown you so far is an example of a medium of expression, and as such is an example of something that is protected by U.S. copyright. However, the contents shown in those videos and photos were generally all examples of things that cannot be protected by U.S. copyrights. So it's often important to distinguish between a particular medium of expression, such as but not limited to a video or a photo as in this example, versus what's actually shown or portrayed in that particular medium of expression. For example, us U.S. copyright attorneys will often say an idea cannot be protected by U.S. copyright, but the expression of that idea can be protected by a U.S. copyright, which is something we noted above. Again, consider a photo of some idea. The photo is an expression of the idea. So while the bare idea by itself is not protected by U.S. copyright law, such that anyone is free to use that idea that's shown in the photo, that particular photo of that idea that is the expression of that idea, the photo, can and often generally is protected by U.S. copyright law, such that copying of the photo is not allowed unless the copyright owner of that photo gives permission for the copying and or use of the photo. But sometimes the contents shown in a particular photo might be something that is capable of being protected by U.S. copyright on its own without the photo. So for example, consider a photo of someone's original artwork, such as but not limited to a photo of a painting or a photo of a sculpture, a photo of a drawing, etc. So it's basically we have a photo of someone's original artwork. Now the original artwork, because it's a creative work on its own, is generally going to be capable of supporting at least one copyright in that original artwork. And the photo of that original artwork might support an additional copyright. So technically the photo would be something what we call a derivative work of that original artwork. And technically the photographer would need permission from the artist of the original artwork to create and or use the derivative work of the photo. In any event, with U.S. copyright law matters, it's important to always look at what type of medium of expression do you have here. Like, is it a literary work? Is it a video? Is it a photo? Is it a pictorial work, a motion picture, an audio-visual work, whatever? You got to look at what is the medium of expression. Then you also have to look at what's the content of that expression, and does that content that's being depicted, does it also warrant its own copyright or not, right? So you got to be aware of those distinctions. Lastly, if you are interested in doing your own research into this topic of subject matter that cannot be protected by U.S. copyrights, you can check out the following source materials. So the first one would be what's called Circular 33, and this is from the U.S. Copyright Office. And in this particular document published by the U.S. Copyright Office, in Circular 33, the U.S. Copyright Office goes over a number of things which cannot be protected by U.S. copyright. Next example would be Title 37 of the Code of Federal Regulations, Sections 202.1. Another example of source material to look at would be a U.S. federal statute, a U.S. federal law, and this is Title 17 of the United States Code, Section 102, Subpart B. And lastly is Title 17 of the United States Code, Section 105. And Title 17 of the United States Code, Section 105 is a particular law that we actually did not really touch on in this particular video, which in general states that the U.S. federal government does not generate copyrights when it makes a creative work. However, the U.S. federal government can acquire a copyright. They just don't create copyrights on their own. In any event, all of these four different items here, these all relate to subject matter that's generally not protected by U.S. copyrights, but the last one is kind of not necessarily entirely on point there. My video here has largely gone through Circular 33 as well as going over Title 37 of the United States Code of Federal Regulations, Section 202.1, and as well as touching on Title 17 of the United States Code, Section 102, Subpart B. But you can do a Google search and bring up any one of these documents on your own. So you can look at Circular 33, you can download it as a PDF file, and you can use Google to pull up, the CFR or the United States Code sections and look at the actual regulation or the federal statutory law if you'd like to. So this has been private U.S. copyright attorney Eric Kelly, and I do work with clients from all over the world and all over the United States. And in addition to being a copyright attorney or lawyer, I'm also a trademark and patent lawyer. Copyrights have been the subject matter of this particular video, and copyrights in general deal with protecting creative works, whereas trademarks deal with protecting one's branding, and lastly, patents generally deal with protecting inventions, so basically new and non-obvious inventions. And then lastly here you can see contact information for me, phone number and emails if you want to reach out to me regarding any intellectual property matters, copyright matters, trademark matters, patent matters. I'm happy to discuss those with folks. Please like this video and subscribe to my channel to help me reach others about intellectual property matters such as copyright matters, trademark matters, and patent matters. And here's some of my suggested videos on U.S. copyright issues. Thank you.